Ladies and gentlemen, we'll now start with our next session. To reiterate today's event, Nyaya Nirmaan, Reimagining India's Legal Foundations for Viksit Bharat 2047, brought to you by GCAI. This session for the evening is themed Reforming the Law on Damages. This focuses on areas like developing a statutory framework for damages in commercial contracts, bringing predictability and fairness in business litigations, and reducing judicial inconsistency. I will now invite the stalwarts of the industry to shed light on the topic. Firstly, I would like to invite our moderator, Ms. Sherina Petit, partner at Stewarts Law. She holds the dual leadership roles of Head of International Arbitrations and Head of the India Practice. Recognized as a global elite thought leader, she specializes in high-value, complex cross-border disputes. Now, I would like to please invite our distinguished guest, Shri Gourab Banerji, Senior Advocate of the Supreme Court of India. He has previously served the nation with great distinction as the Additional Solicitor General of India. Welcome, sir. Also welcoming Ms. Pinky Anand, Senior Advocate at the Supreme Court of India. She has previously served the nation with great distinction as the Additional Solicitor General of India. I would also like to welcome Shri Sudhanshu Swaroop KC, Barrister 20 Essex. We also have joining us Ms. Sudha Rani Relangi, Member Legal, Petroleum and Natural Gas Regulatory Board. I would also like to welcome Shri Hitesh Jain, Advocate and an esteemed member of the Law Commission of India. We also have joining us Shri Jagdish Chandra Solanki, Central Government Standing Counsel and esteemed advisor to the Ministry of Law and Justice. Also, please welcome Daksh Ahluwalia, founder and principal of Aikyam Law Offices. And finally, we have our GCAI representative. Please join me in welcoming Dr. Vivek Mittal, Executive Director for Legal and Corporate Affairs at Hindustan Unilever Limited. We are truly privileged to have all of you stalwarts here today, and I would now request you to please commence the session.
Good evening, everyone. I'm delighted to be the moderator for this panel session on reforming the law of damages, and we've got a very distinguished panel here today. We do have limited time, so I'm going to get on with just giving a brief introduction and then with having a discussion with the panelists with some questions. For several years, the basic framework and substantive content of Indian private law mirrored English private law. The drafters of the Indian Contract Act 1872 and the Specific Relief Act 1877 were actually English jurists, and several illustrations in these codes were based on well-known English cases recorded in English equity reports. However, it would be premature to write off the origins of commercial remedies in India as one that began with codification. Court-granted damages, specific performance, and injunctive relief for contractual breaches, depending on applicable law, that is, personal law and customs. It was through the process of codification that damages became the primary remedy and specific performance the exception. In the nearly 150 years that have passed since the colonial codification exercise, several moments have shaped the law of damages in India. Chief amongst these is India's changing economic landscape. Having grown to be the world's fourth largest economy, responding to this change, the legislature amended the Specific Relief Act 1963 in 2018 with the objective of improving contract enforcement, particularly for infrastructure contracts. The amended Act does away with the adequacy of damages rule, marking a departure from English law. Yet, challenges remain that merit further consideration of India's damages regime. Mr. Sanjeev Gimawat, who is with us in the audience and is a thought leader in this field, recently wrote an incisive article about why India must overhaul its damages jurisprudence, where he remarks, and I quote, "In this changed landscape, continuing with a damages jurisprudence designed for a protectionist era is illogical." He touched upon amending the law on liquidated damages, which is not only at divergence with international practice, but also undermines contractual certainty by insisting on genuine pre-estimates of loss. Other challenges include judicial delays, which significantly impact the value of damage decrees, skepticism over whether the existing regime is sufficient to address the various causes of action that can arise from sophisticated commercial transactions. Today, our panel will consider whether and to what extent the law of damages should be reformed to address these challenges. We aim to discuss three aspects. The first aspect will be on liquidated damages, the second on specific relief, and the third on the payment and recovery of damages, including proposals for legislative reform. So I first turn to Section 1, which is on liquidated damages. Now, on liquidated damages, Section 74 of the Indian Contract Act 1872 sought to break away from the common law distinction between liquidated damages and penalties. Despite this, courts in India have actually imposed the common law into the code. That is, applying the law against penalties, such that a liquidated damages provision in the nature of a penalty is actually unenforceable. So my first question is really to Mr. Banerji. Considering the inconsistent decisions on the test for reasonableness, should the Indian Contract Act 1872 be amended to set out a criteria for reasonableness? Should this be in sync with the modern penalty rule, that is, if liquidated damages is not an unreasonable pre-estimate of damages, it will be enforced?
Thank you, Sherina. First of all, thank you for inviting me. This is quite an interesting and unusual topic. Normally, people don't discuss damages, though it's the most important part of the equation in any matter, because that's where the money lies. And the topic that you flagged for me is Section 74, and whether it should be amended or not. And I would say the answer is yes, is the short answer, but in the interest of time. But I will definitely tell you why, in my opinion. So you've got to dial back to Section 74. The idea of Section 74 was actually to solve a problem, which was there in English law, which was this distinction between a penalty and a genuine pre-estimate. So it was a section designed to solve a problem, cut the Gordian knot, have a simple formula, and close out this distinction. Unfortunately, when it came to the Supreme Court in the 60s, we all know the cases of Fateh Chand, Balkishan Das, Maula Bucks. I'm not going to bore you with the judgments. The attitude of the Supreme Court was very different then from what it is now. It was, they were suspicious of an onerous burden being put on parties who were not in a position to negotiate. So you had this judgment which essentially said two things. One, they said, well, first of all, you've got to prove loss. Now, if you read the section, it says you don't have to prove loss. But they introduced this in. And then they said, not only do you have to have some sort of loss, but then you will only get reasonable compensation, and we will tell you what reasonable compensation is, and pluck out the principles of 73, push it into 74. This has happened in 63, and now our courts are stuck with that. In fact, in Kailash Nath, which is Justice Nariman's judgment, we had quite a spirited debate in another forum, and I essentially told him that I didn't agree with the judgment. And his one answer was, I'm sorry, the Constitution bench said this, I am bound. So obviously we need a change. Now the question is, what is the change? What has changed? One is, you know, the whole purpose of having liquidated damages is that you don't have to go to court. Because you see the formula, give the money and get on with it. And how do you achieve that? Interesting, and I of course read Dr. Ghemawat's article, but there's one thing I will add to his article, which is this. This same section is there in Malaysia. It's section 75 of the 1950 Act. And they have a judgment in a case called Cubic, which is completely different from our Fateh Chand and Malkishan Das. On the same section, they initially followed Indian judgments, and then when Cavendish and Magdesi came, they course-corrected Cubic Electronics Mass Telecommunication. Very interesting judgment, 2019 MLJ 15, worth a read. So the short point is this. You should not be required to prove loss. You've already agreed to what you've agreed. You should not get section 73 in there, because that will drive you to litigation. Secondly, if you have negotiated it, then whatever is there in the formula is what is there, presumptively. What is the joy in then saying, I will give you reasonable compensation which I can determine? Then you are back in court. So either way, the section, I would say, a very bold judge will refer the matter to 7 judges and follow Cubic and overrule Fateh Chand. It's not going to happen. So the only solution is some sort of explanations added to section 74, saying you don't have to prove loss, don't bring in section 73, and 2, yes, in a very onerous case, you can revisit it, but presumptively what is there in the formula should be reasonable, because that is what has been negotiated. You can't have commercial matters equated to employment contracts and one side fits all. So we in India don't have the ACTA, which is the Unfair Contract Terms Act. So so answer, yes.
Thank you. Thank you for that. That was excellent. We have another question now for Ms. Dr. Pinky Anand. Pinky, what about the requirement to prove actual damage or loss ex post? Should the test be ex ante, such that it is only relevant if the clause reflects an amount unconscionably out of proportion to the maximum loss or damage that may be sustained at the time of making the contract?
Sherina, thank you very much. I think you're brilliant. You not only ask the question, but you actually give some part of the answer. I'll just go back to praising Sherina first, to say that not only does she give the question, but she gives part of the answer as a cue. So it happened in the first, and now, of course, this is the second. But after having heard Gourab on the subject, and really, I keep wondering, how have we done this entire practice of having a provision of law which provides for something, and we've interpreted it completely reverse? So for me, the day is staged as reverse engineering. Now, we have to go into that process somewhere. There are 2 ways possible. And what kind of a process may be done is, one, the substantive correction. Gourab pointed out rightly that it may go to a 7-judge if it so happens. The alternative is legislative amendment. But legislative amendment would be strange. The law actually says you don't have to prove actual loss and damages. But nonetheless, we are able to do it when we want to. So I think explanations could be added very validly to take it out of the circuit of this entire trajectory of litigation as it goes along, because now we are dealing with Commercial Courts Act. We are dealing with the entire process of med. We are dealing with resolving disputes in the fastest possible way, efficiency, and what have you. Now we need to get our substantive course corrected for the reason that if you have a provision which is amenable to a certain construction, that construction is always going to happen. And that construction today unreasonable, the quantum, what it should be, is really a question in the open. To come back to one of Sherina's questions, to say, should it be what? So I come back reverse engineering. It should be presumed liquidated damages is actual, whatever is discussed. We don't have the time or energy now to dispute all these issues time and again in various jurisdictions. We just have to stop somewhere. And commercial efficacy demands that you actually give or you get what you committed to. The commitment reduces the uncertainty, the time gap, the processes, and then ensures that you don't want to take advantage of delay. Everybody knows that you actually work on delay as a system. So you want to reduce that. So reverse engineering, yes, Sherina, the test of what it might be would actually be that the liquidated damages stand, except where they are disproportionate or onerous, and whether we review it by the 7-judge bench or the 9-judge bench, or we do it legislatively, it's high time we do it, because we are working on Viksit Bharat, 4th largest economy, FDIs, everything else that we have to go with us. If we can't reduce our ease of doing business, and we're not very, very high up on that, we've improved, but that index has to go up. And the only way to improve the index is to reduce uncertainty, vagueness, ambiguities, and to make it clear. So what was clear has to come back in one way or the other. The earlier regime actually also, I will add to what Gourab said, worked on a socialist pattern of thought. That rescue, the David and the Goliath fight. In 1872, save the poor people, don't put them to terms. But today we are not in that circuit. We have far exceeded into a Viksit Bharat, as I said. So today you have people who are of equal strength. The bargaining positions are somewhat equal. Of course, there'll be always some inequalities, but at the same time, you have mostly equal bargaining strength. So reduce it, make it certain, have liquidated damages stand where it must and should, and only reverse it in the case of where it is possibly disproportionate. And the proportionality test has been used in US very well, in fact, as a criteria to do so. I think we can take examples from wherever, and we sit together and take this up to its logical conclusion.
Thank you very much for that. And there's a lot of takeaways in what Dr. Anand just said. Because time is short and we can spend literally an entire day talking about liquidated damages, I'm going to move on to specific relief. Specific relief was previously equitable and discretionary. This, however, changed in 2018 with amendments to the Specific Relief Act 1963, with limited grounds for refusal of specific relief, and made specific relief available as of right. One of the aims of the 2018 amendment was to increase investor confidence by improving enforcement. And my question here is to Mr. Sudhanshu Swaroop, who's from England and Wales and who's a KC from London. Sudhanshu, in England and Wales and other common law jurisdictions, the option to pay damages is one of the markers of investor friendliness and is the preferable mode of enforcing contracts. Do you think this is different when it comes to India? Particularly, is the deterrent effect involved in making specific performance a primary remedy more desirable than the autonomy to break a contract by paying damages? It would be great if you give a little overview of England and then talk a little bit about India.
Thank you, Sherina. Well, I speak from the perspective of a UK practitioner. And in the UK, for a claimant alleging breach of contract, the primary remedy is damages. Damages is available as a matter of right, and the principle is that the damages should put the claimant in the position he would have been in but for the breach. There is a jurisdiction to go to the court and ask for specific performance, but that is a discretionary remedy, and the court will not grant specific performance of a contract if damages would have been an adequate remedy. So, for example, situations where damages might not be an adequate remedy could be where, for example, there's a contract for the sale of a unique item, such as an antique vase, or typically contracts for the sale of land, because land is considered to be unique. But again, just thinking about the UK perspective, this then translates into the mindset of litigators, because whenever you're instructed to plead a case, you rarely think of specific performance. You go straight for damages, and you plead out damages with a view that there's going to be a exchange of pleadings, witness statements, a trial in 1-2 years' time, and then perhaps further proceedings to enforce the damages claim. And I'm intrigued by the India amendments to flip this round and make specific performance a primary remedy available as of right, because the title of this conference is Reimagining India's Legal Foundations. I do wonder whether in the UK we need to reimagine the way we treat questions of specific performance, because fundamentally business people want to get on and perform contracts. They don't want to be stuck in several years of trench warfare, litigating, and then trying to enforce a judgment. So I'm not going to try and give any kind of insight into how this does or does not work in India, and I'd love to hear from Indian practitioners about this. But in terms of reimagination, I can see a case for reimagining the way we do things in the UK.
Thank you very much, Sudhanshu. And I actually have a question for any of the panelists that might like to chime in. In your experience, are courts ordering specific performance more readily as a result of the 2018 amendment? I can see Gourab is just raring to go.
I'll answer that and run. I think the answer is that courts don't have that many final decisions in commercial courts, but certainly arbitrators are now rethinking what they're doing and awarding specific performance rather than damages, though it's a task to educate arbitrators about the amendment, and it's a massive change of mindset, both for the arbitration community, the arbitrators, the lawyers. We've all grown up on the English law, which is damages first. You can blatantly breach a contract and just pay money and get out of it.
Yes.
But our thinking now in India, and I think this is forward thinking, this is a better position than what that English law has. And I think it's a very positive thing that we insist now that you keep to your end of the bargain and carry it out. So yes, it is happening, and we are pushing that, and awards are coming more in that sense.
Sure. Thank you. Did we have another contributor on the panel to that question?
So I represent corporate here actually, and we actually go for litigation. The the issue with this entire process is that lawyers, and I'm also a lawyer, but external lawyers, they see it completely differently versus us. For us, it's always is the balance between getting our work done versus money and how efficiently we can get it done. I think from our point of view, when we see Indian legal system, our first port of call is how to get it done. Damages is one area which is typically, if you pick up last 10 years, 20 years cases, mostly goes in infrastructure contracts. But companies like us, we want to get the work done. And how to get the work done is a challenge even with specific performance, and we have gone through multiple times. That even through specific performance, you have judgment in your hand, but party is not doing it rightly. You struggle to get it done because the intent itself is not to do it. That's one point of view. Other point of view is whenever anybody comes to me and says that, oh, I want to claim damages, and let's say damages amount is very high, my first response is, are you willing to spend 5 years? Are you willing to spend 10 years? If the bigger the amount, the long term of litigation is equivalent to that. So I think and I have dealt in many jurisdictions, I think my idea is that there are jurisdictions where people do fear liquidated damages. They do understand that enforcement is pretty solid. And in-house lawyers do tell them that, okay, go ahead, take this fight head on. You will win if there is a breach. So I think we need to fix this balance between damages, specific performance, and enforcement, all three together. Unless we fix all three together, if any one of this is not working, then probably we are not in the right place. Even from investment point of view in India, if we have to look at 2047 and draw more investments, then we need to fix this process. Thank you.
Thank you. That was a really useful perspective from an in-house counsel perspective. And we have one more panelist, Mr. Jagdish Chandra Solanki, who's going to give us his views.
Thank you, ma'am, for inviting me. See, regarding this specific performance and damages is concerned, the era is pre-2018 and post-2018. In pre-2018, the word in section 10 of Specific Relief Act is used may be enforced. In post-2018, an amendment has happened, and the term which replaces shall be enforced. So the era is changed. Earlier, the specific performance was discretionary in nature. It was not claimed as a right. Now, post-2018, because of the amendment, now it is nothing but a statutory right. Yes, there is an exemption, there is a limitation. Limitations are prescribed under section 11, subclause 2 of Specific Relief Act, and 14, section 14, and section 16. So if any case falls under these exemption limitations, of course, damages can be awarded. But the primary objective is to perform the contract. So specific performance as of now is a right rather than a discretionary or a judicial indulgence.
Thank you. Thank you. And now we move on to the final section of the, which is on payment of damages and legislative proposals. And my question is to Ms. Sudha Relangi. The government is increasingly promoting mediation, especially in lower value contracts involving the government. In your experience, has mediation proved to be effective for parties to be compensated for their loss?
Thank you and good evening to everybody. And the specific question which is being discussed by all the panelists, in addition to that, I would like to add that while handling the litigation, be it commercial disputes or the contractual obligations, what I would like to see while adjudicating these matters is the aspect of enforceability, whether they are able to be enforceable. If they are enforceable, time is the essence of the contract. So it is high time for us to go for law reforms and then amend section 74, which is handling the liquidated damages to be offered, because it is something interfering with the commercial wisdom of the contracting parties. So the commercial wisdom of the contracting parties, while taking the risk factors, they have entered by assuming one amount while entering at the time of contracts is being reassessed by the courts. So this needs to be addressed.
Thank you so much.
Thank you.
Dr. Anand, can I ask you, have you seen in your experience whether mediation has proved to be effective for parties to be compensated for their loss?
Indeed, yes. And I think the regime that we've entered into recently, with the Mediation Act also coming into being, you find that basically parties in commercial interaction wish to actually end the dispute.
Yes.
So obviously mediation being a source of efficient disposal is something that works. And parties want to retain not only this issue of having solved their problems, but for going for further interaction. You want it a continuing business relationship. Yeah. So you don't really want to come out distressed. As far as mediation is concerned, mediation actually tries to work out that both sides go, it's a win-win, as we say, yes, in mediation. Nobody really loses out fully. You find some midway solution which works out. So I think if you can get rid of the aggravation, and I actually find that in commercial interaction or disputes, you basically have a higher chance of mediation because emotions don't run so high. You know, we are not in the old patriarchal system of business which runs down a family only. It's gone way beyond that. Yes. We've come into commercialization of all sorts, including corporatization of the world, and India in particular. So within this, everybody's open to it. You're not really taking it personally. There's no personal engagement. And I think mediation has worked very successfully, and hopefully with the initiatives that we've been launching, all of us, and it's going on, catching with a momentum at this point of time, you're encouraging it, and so mediation, and not only mediation, med, and those combinations that I think we can look for, because now mediation firstly has a binding effect, not international, I'm afraid, so far. We've been mooting for it, but for national we have recognition. The combination of med is again something that can be looked at very successfully and is being worked on.
Actually, Pinky and I spoke on another panel on med. And actually looking at statistics on mediation, when I was preparing the questions for this panel, about 93% of disputes, international arbitration disputes, that go into mediation tend to settle. So that's really good statistics, and I think that's been a great initiative with the government as well. My next question is really to Daksh on good faith. While good faith between parties is a critical factor during negotiations and while entering into a new business relationship, there is often no place in Indian law for damages for breach of the implied duty of good faith, quite similar to English law. Could you elaborate on the need for the courts and the legislature to be more open to damages for breach of the duty of good faith? Would parties be open to quantifying the amount of the duty into, say, liquidated damages whilst entering into commercial contracts? What are your thoughts, Daksh?
Yeah, so thank you for that, Sherina. I think the question is in two parts. One is there an implied duty of good faith where the contract does not stipulate for one? And the second part is where the contract would stipulate and then therefore there could be liquidated damages for breach of the duty of good faith. And you're right to say that in the first instance where there is no implied duty of good faith under Indian law, there are two High Court judgments, one from the Delhi High Court and one from the Kerala High Court, that observe, and it's really an observation which goes to say that there is a duty of good faith in every contract. Now, whether that's been followed across arbitral panels and in awards, we've not seen that really. There's just observations that are there and maybe made in a very, the judges are just making those observations when they are not central issues to the case. So, should there be an implied duty of good faith, is really a question that develops, and we can follow from English law, where there is a 2009 English judgment which says that there should be an implied duty of good faith in relational contracts. Exactly. And that's a fairly good precedent to follow. I don't think Indian law has really evolved to that extent. Coming to the second part of your question, whether you should have liquidated damages, you could only have liquidated damages where parties to the contract include within the contract that there is a contractual duty of good faith, an obligation really written down. And very often you can have that, and presumably I think practitioners and draftsmen who are looking to draft contracts, which are relational contracts, taking from English law principles, should then write in the contract that there is a duty of good faith.
Yeah. I mean, I know there's this big debate because many, in French law, they do recognize the concept of good faith. So that's been really, so a lot of clients, particularly from India, ask us those questions. Well, why can't you import that with English law? But thankfully, because of the relational contracts point, that's been helpful, at least from the good faith perspective in England. And it would be good for India to consider adopting something like that.
I think a case-to-case standard would be better instead of a blanket approach where you just imply it. It's also the question of party autonomy. India and the UK, I think, have recognized party autonomy and the ability of parties to agree to terms. So would you then imply a duty of good faith if I decide to sell a company that is valued at 100 crores at 50 crores? Then that's my choice. So do you imply that duty of good faith that there was a discount? There are both sides to it.
Thank you. Thanks, sir. So Sudhanshu, I don't know if you want to chime in something about English law and good faith.
Well, the context I've come across it. The context I've come across it most recently is where a contractual clause provides a general discretion that the other party may do X in the following circumstances, but at their discretion. And it's in that context that the question of whether there's an implied limitation of good faith arises. And certainly in that context, there's a lot of case law that says an English court will have no problem in implying an obligation of good faith. And in the case I was involved with, it actually ended up being determinative. But outside of that context, I've always encountered a lot of resistance from English courts because they regard it, like you say, as French.
Yes.
And they don't like that.
Yes. Well, thank you. The next question is for Mr. Solanki. Should timelines for payments of damages be prescribed by legislation, Or do you think it's sufficient for courts to direct the payment of post-award interest? Should the consequence of non-timely payment, which is payments like adverse costs, be prescribed?
Yeah, so I think you put this watch in front of us, which is reminding us that we left with no less than 8 minutes, and
Yes.
I think one more speaker is also left. Nonetheless, I'll try to be specific. So you have 3 questions in one. One is timeline, second one is interest, and third one is post-award interest. In general law, in India, CPC section 34 provides for interest part. And one more legislation, that is Interest Act, that's also empower, section 3 empower the judicial forum to impose interest in case of awards and judgments. Now, in this, the issue is post-award and the penal interest. If the obligation is not met out, award is passed, judgment is passed, but within the time frame given by the court, if the award is not met out, condition is not fulfilled, then whether post-award interest can be imposed or not. Yes, court has all discretion, but the section 3 of Interest Acts prohibit for compounding interest. So you can't go for compounding interest. So the only remaining situation is that you can award only simple interest. Or some penal interest is 6%, or you can go for higher rate of interest, could be 9%, 10%, 11%. So yes, court can award it. But is it enough? To my mind, yes. My question is mixed, answer is mixed, but yes, it can be enough, but certain things can be also added. In your contract, if you have specific conditions that in case of post-award, there is a specific condition of any penal interest, then court is bound to do it. Second point, yes, there could be a requirement of amendment in some provisions, like where is a case flow is huge, like an infrastructure contract or construction contract, where case flow is huge, some provision for penal interest can be added, so that the trust and faith in Indian judiciary can be intact.
Thank you very much for that.
I'll just add, Sherina.
Yes, please.
You know, on the aspect of interest, much as I'm not going to what interest there should be and which stage, etc. I'm fully, the law provides for some things, and maybe you could add into that. But actually, I am against this whole concept of providing for interest per se, as opposed to having a speedy disposal and enforcement of the actual dispute between the parties. In commercial wisdom, you don't really look for being awarded the money as an alternative, because money is invested into the whole business as an expectation that it will deliver within a certain time span of its own, and it in turn leads to much more further businesses. So interest providing, and particularly I will say in the Indian context, I mean, people feel they'll pay some interest on it, fine, we'll pay it later on, we'll find some reason, we'll delay that proceeding, and that doesn't really work out efficiently very well. And when we are talking about millions and billions in corporate businesses which are coming up, I'm really all in favor of providing for the expedition at the first instance. Interest, as definitely it has to be provided, there's no choice, and we do have the provisions, but really let's concentrate on the first part and the enforcement of that.
I can see Vivek Mittal leaning very much forward and enthusiastically from a business perspective on that.
So I think before I jump to interest, I want to comment on 2 things. One is good faith and other one is mediation, very quickly. I don't want to fight one more fight of good faith before I fight the actual fight. So very clear, because as soon as good faith is introduced, I need to fight good faith, and when good faith is proven, I need to go to actual issues. So I don't want good faith. I think I'll write in a contract and live with that. On mediation or arbitration, one suggestion which I've been advocating is CSR funding towards access to justice, where we should tap the retired judges or senior lawyers, and corporate should pay them. And with that, we should create a mechanism of tiered fees, that if your damages, if this much, then this fee you pay, and that's done. I think we should move to that, and that's the right way to go to access to justice, by the way. And third thing, interest. If I'm going for damages, then I would want my interest as well. That's where I am, very clearly. Because otherwise, if the matter is going on for 20 years, I don't want to stuck with what I claimed 20 years back. I want damages I want interest as well, with the interest which is linked to inflation, by the way. And maybe linked to some bank or something, maybe. Thank you.
Thank you. And that actually leads me very well into my last question, which is for you. Do you consider that the current statutory framework on damages and the judicial regime on enforcement offer adequate protection for your business interests? And what change would you consider would improve the current framework?
So I think I covered it in some form or other.
You did. I just wondered if you wanted to.
Yeah, I think the biggest thing is enforcement.
Absolutely.
If
Which is what Pinky just talked about as well. Absolutely.
If we fix that, then we are almost there. Enforcement, that's one. And then time to reach to finalization of dispute. Yes. And we keep discussing internally, and we were very recently discussing in my company that, oh, this case is in High Court. I said, be prepared to go to Supreme Court, and be prepared to spend 3 more years on this. So I think time to reach to the finality of dispute is one thing which I would want to see, certainly.
So just one more point on
yes,
improving access to justice and how you can look for enforcement is like Mr. Mittal just said, everybody wants to go to the higher court because there is no consequence of going to the high court, and the English law follows a loser pays principle, which if introduced in India, you could have a situation where practitioners then really need to think about whether they want to fund their own costs as well as costs of the other party. And if you bring in that principle in a serious way, we've had courts award 20,000 rupee costs, 1 lakh rupee costs, when senior advocates who are charging much more than that are appearing, even lawyers, firms who are charging much more than that are appearing. But if you have the loser pays principle come into India probably in a codified form or by judicial intervention, then that would really improve enforcement and objections, frivolous objections that come.
I think that's a great takeaway, Daksh. That's a great comment. We have 1 minute and 27 seconds, so I'm going to have a final question to any of the panelists. Should the law prescribe guiding factors for determining quantum of damages, perhaps by way of schedules to the statute, or better guide parties and the court, or will such a schedule restrict the courts instead of guiding them? Does anyone want to? Oh, thank you, Pinky.
No schedules. I think when we are contemplating liquidated damages, particularly, we are not talking about unliquidated damages principally. Yes. So when we talk about liquidated damages, to restrict the party's autonomy is probably unthinkable for me. I feel we have to leave it there for the party's wisdom, and for restricting the courts, and in its own way to amend the legislation to see that we ensure that the party's autonomy is upkept in all ways. It's upheld, it's preserved, it's enforced, and that is what really should work. So prescribing that not. And I do want to add in one part on judicial reform as far as this is concerned, or legislative rather, time limits. You asked a question earlier whether it should be mandatory or whether it should be, or time limit should be set or left to parties.
Yes.
But really, we've seen in the Arbitration Act, Sherina, the Arbitration Act and the amendments that we have brought in as a country has really led to improved efficacy in terms of time. And I think we need to introduce these mandatory time limits. We do have commercial courts. We can actually set a different tone and tenor to the commercial courts, national in the first instance, then getting on to the international as well. That's the scope we really need to work on.
Thank you very much, Pinky. And with that, I've been told time is up. And so I would like to close this panel session by saying thank you very much to our fantastic panelists for an engaging discussion, and to you for being an engaging and listening audience. Thank you very much.
Sherina, I must add in here that you are one of the best known arbitrators in the world, and for you to be moderating such a session in such a grand way, thank you very much.
Thank you. Thank you. Thank you.
Thank you so much, all of you, for such a lovely session. I would just request you to please stay on the dais. I would now invite Ms. Neera Sharma, founder GCAI, Group General Counsel and CEO, Board Director, Systema Smart Technologies, to please come and do the felicitations for our guests. I would please request all of our guests to please come together for a final photo. Thank you, everyone. We will commence with our next session in just another minute.